Well, good evening, everyone. Hopefully you can hear me at the back of the room. Good. So I haven't lost it. You may not know me. You certainly won't know me from the photograph that went out with the publicity. I'm one of the new High Court judges and I sit in the Court of Protection. And it is my very great pleasure to have, I think, my first speaking engagement. So thank you very much for inviting me. A general welcome to all of you in the room and to those online. I'm told there could be up to 1,000 online. At the last count, it was nearing 250. Some housekeeping. There are no fire alarms due. So if it goes off, make your way to the stairs or to the point of contact for evacuation of the building. The seminar is being recorded and will be made publicly available afterwards. So there's no need to take notes. Hopefully you can sit back and listen to what should be a very instructive talk. There will be questions and answers at the very end. And I'm told that those online can pose the questions through the chat room. Names won't be read out from the people whose questions are chosen. And of course, time will be limited, but as many as can be answered will be answered. We're aiming to finish at 6:45. Speakers are strictly timed to 15 minutes, but something's gone wrong with the plan because I don't have a watch. So let's see how this goes. The topic, anorexia in the Court of Protection. The assumption is that you all have an interest in the topic, otherwise you wouldn't be here. And so they're going to dive straight in to the interesting aspects of it. And the hope is to stimulate debate, because although obviously I'm always right in my court, you will know that sometimes in life there is no one right answer. You have 5 speakers. The first is Victoria Butler-Cole, now a Silk. And my briefing note tells me very little about her, but she may not remember, but I remember first meeting her. It was 2006. Neither of us were old enough. It was before Mr. Justice Holman in Swansea. And it was a distinguished lineup, not because I was there, but because Alex Rupp-Keane was also present, and I remember it well. Hope Virgo has joined us and she's going to speak. She's an author and multi-award-winning mental health campaigner. She's creator of Dump the Scales campaign, which aims to stop patients being turned away from support because they're not thin enough. Nicky Smith is on the link. She is a parent and carer and will give a real life experience and bring depth from that perspective. Dr. Agnes Ayton is also on the screen. You'll see her there. She's a consultant psychiatrist with 40 years of experience working at the Oxford NHS. I think that's a foundation trust. Forgive me if I don't get that right. I'm from Wales, where we do health properly. She is currently the Vice Chair of the Royal College of Psychiatrists and Faculty of Eating Disorders, having previously served as chair. Numerous published articles and basically an expert in her field. And Dr. Ty Glover, I was going to call him T Glover, if you're Welsh, you'll get that. Thank you. He gets it. It is absolutely. It is present in the room, a consultant psychiatrist who I think has been instructed in 90% of all the reported cases from the Court of Protection concerning people with anorexia. A distinguished guest list indeed. The topic is interesting, it is stimulating, it can be emotional, and it may trigger some. If it does, beat, I'm told B-eat, put it into your Google search engine. Other search engines are available. That is not a judicial endorsement. And you will find, hopefully, the resources you need. Alternatively, SMS shout to 85258. And in England, 0808 801 0677. And you will find eatingdisorders.org.uk can also provide help. But hopefully that's the main part from me. when you've settled down, we'll start. And Victoria Butler-Cole, tonight may I call you Tor, you know.
Wait a few minutes while we find these out in real life. There are some seats at the front. I know no one wants them, but they are there. Brilliant. Great. And well, welcome to everyone who's here in person, and hello to the 430 people who are online. I can't see, which is just as well. And this seminar raises all sorts of really difficult questions. And I'm very conscious that a lot of the people listening to the seminar, maybe even all of us, will have been personally touched by anorexia in some way, whether that's personal experience, friends or family members. They are really difficult topics, and we don't want to upset anyone, and we will do our best not to. We've got a number of speakers at a short amount of time, and that's really deliberate because we want you to hear a range of perspectives, and that breadth is important. And it does mean that all the speakers wish they had at least 10 times as long to say all the things they want to say, and would be frustrated that they can't. But we've got various other documents and a reading list of further reading that's going to be circulated after this evening, which will give you some pointers of things you might want to look at if you want to follow up on any of the points that have been made. One of those documents is a 37-page summary of all the reported cases in the Court of Protection about people with anorexia, which my colleagues Nicola and Mungo, who are sitting here, have prepared with a bit of input from me. And the reason we've done that is that not everyone has time to read all of these cases. And it can be the case that misconceptions build up about what the Court of Protection has decided, how the Court of Protection works, about the sorts of decisions that it makes. And this table, which you'll all get, summarises the facts and the decisions made in the various cases, so that you can get a sense of the sorts of cases that come before the court and the sorts of decisions that the court makes. And amazingly, we have a member of our staff here doing all the IT, so I don't have to touch anything to make these slides work. Although I think I might have to say next slide, please, in the time on the way to get them to move forward. So the summary of the cases, the 37 pages, which I'm not going to try and squeeze into 15 minutes, shows you that there has been an increase in the frequency of cases coming to the Court of Protection about people with anorexia, where trusts are seeking declarations that someone lacks capacity both to mitigate the proceedings, but more importantly, to make decisions about treatment for their condition, including the provision of nutrition and hydration. And very often, what the applications seek is a decision from the court that forcible treatment is not in the person's best interest. Now, technically speaking, you don't need that sort of declaration. You could detain someone under the Mental Health Act and decide to treat them forcibly, because the Mental Health Act gives you that sort of authority. But these are often cases where the patient has been detained repeatedly under the Mental Health Act, and the treated professionals have reached the view that just doing that again isn't the right thing to do. And so they come to the Court of Protection for perhaps a more in-depth scrutiny of that view that they've reached and a decision from the court about whether it's the right one. Oh, I haven't made my slides move. Go and have them make them move. Oh, I need that. Thank you. Right. So there are a number of questions raised by these cases which have been talked about for quite a while. Does it make sense to be able to have capacity to instruct solicitors in proceedings about treatment for anorexia, while at the same time not having capacity to decide about treatment for anorexia? I think there's a simple one-word answer to that question, which is no, it doesn't make any sense at all, but other people think differently. And there's also a question about whether the Court of Protection would ever conclude that someone with anorexia has capacity to make a decision about their medical treatment for that condition, because by virtue of their illness, it is said in every single case, they are simply unable to weigh up the relevant information because that's the nature of their condition. And that's an interesting question because, of course, if you probably all know, the Capacity Act requires decision-specific assessments of capacity, and it ought to be possible for the court to reach a different conclusion. I'm going to look at those questions this evening because one of the things that prompted this seminar was the suggestion that there could be such a thing as terminal anorexia, and an approach taken to patients with anorexia, where the best thing to do is to implement a palliative care plan and not provide an active treatment to them. And that overlaps with the decisions that we've made in the Court of Protection, where in certain cases the courts have agreed that forceful feeding shouldn't be given. And the practical result of that on the ground is that the patients have died, because that was the only meaningful treatment that was going to be potentially offered, and there was nothing else that could help support them to stay alive. So this raises a whole lot of new and really difficult questions. Should trusts ever withdraw medical services from patients with anorexia? What is the range of views among psychiatrists on these questions? And that's a question that I'm really interested in, because when we're instructed in a particular case in the Court of Protection, we have the evidence of the treating trust, and we may have one independent expert giving us a view. But we, as lawyers, don't know in great detail what's going on in the world of psychiatry. What are the internal divisions and debates about these concepts? What's happening in terms of provision of services? Is there a postcode lottery with regards to treatment and approach? If you present for treatment in one county, are you going to get a different answer to if you present somewhere else? And if you are, how should we in the Court of Protection factor that in when we're considering what sort of decisions are in someone's best interest? Because we can't magic up treatment, and we can't enable people to move to a different county where they might get a different offer. Any ideas? This isn't like me. It doesn't really matter, they're not very exciting slides, as you can see. So I just put a list of questions on my slides, really. My talk is really just asking a load of questions and not answering them, because I'm more interested in the answers from everyone else. These are questions that have sort of thrown themselves up. Is there evidence that discharging people from services can actually help by restoring control to them? That's an argument that's being put forward in the protection. And what options actually are there for treating someone who has severe and enduring anorexia? And is there anything other than forced feeding that could actually be considered by the court? And are there any general principles or factors that can be identified which might indicate whether it's even appropriate to be considering that someone is essentially receiving palliative care or is no longer to receive forced feeding? And that's an important question to lawyers, because we don't have any of that complexity, but we want to know the questions to ask. We want to know whether our eyebrows should be raised when we read a particular set of papers. We want to know how much effort we should be going to find second opinions or third opinions or fourth opinions. And we want to know what is poor practice and how can we spot it? How do we know if the trust says we've done everything, whether that's right or not? And what can we do if there's no one offering anything to a patient, because no one thinks that forceful feeding is a good idea, but there's no specialist unit offering a place? What else is there? And what should the care plans that the court is asked to endorse look like? Because often with the focus being on forced feeding, there might not be so much focus on what is going to happen in place of forced feeding. And then how should the court treat people saying, I don't want to die, but I cannot bear to be forcibly fed again? Such a difficult question, because the Mental Capacity Act requires you to take seriously the views of someone who presently lacks capacity, but also views that they had in the past. And as I think we might hear from Hope, what about the views that they might hold in the future? And it's really difficult to know how to weigh all of that up. And very difficult, I think, for a judge faced with an articulate patient saying, I don't want this to happen to me again, please, please do not order it. For a judge to say, I'm going to override that very clearly expressed and consistent wish based on personal experience and informed by your life experiences to date. So those are a number of very difficult questions. And as I say, I'm not going to try and answer any of them, but I'm hoping we might touch on some of them in the rest of these talks and in the discussion. And I'm now going to hand it to Hope, or I should not ruin Nicky's talk by showing her slide in advance. And Hope is going to speak without the benefit of PowerPoint slides.
Thank you very much, everyone, for joining and also for inviting me to be part of this today. So I know you've had a brief introduction already to me, but just, I guess, to introduce myself again. So my name is Virgo. I am an author and mental health campaigner. As you heard, I founded a campaign probably about 3 years ago called Dump the Scales, which is all around making sure that there is the best possible treatment for people affected by eating disorders. I've worked closely with Number 10 over the last couple of years, and now I spend my time working in schools and with corporates all over the world, trying to ensure that people have a proper understanding of eating disorders. So looking at it very much from a scientific basis, and also working to try and challenge the stigma around it as well. So today I'm here to speak from my own experience of being in recovery from anorexia, but also on behalf of the thousands of people who contact me every single week with their experience. People who send messages to me crying out for help, desperate to live, desperate to access treatment, and desperate for that suffering that they live with on a day-to-day to end. I stand here as someone who is still in ongoing recovery from anorexia, an illness that I've had since I was 12 years old and I'm now 33. One that hospitalized me at the age of 17. When I was 17, I wrote in my diaries that I wanted to die. And today, I still stand here and I say that there have been moments in the last couple of years, even still, that I wish that I had been marked as untreatable. Moments when I wished that I'd been left alone. Moments when I wished that I'd been moved onto a palliative care pathway because I didn't feel like I had a choice over what I was feeling. I've now got a 19-month-old baby, but even during my pregnancy, I still had those moments when I wasn't fueling my brain in the right way, where I had those same thoughts. But is that a reason to mark someone like myself as untreatable? The reality is, if you haven't been through an eating disorder, or to some extent supported someone with an eating disorder, you won't fully understand the mental torment that we live with day in, day out, of what it's like to get up each morning and live and fight in those moments. That relentlessness, the battle, the stigma that we face from people that think it's a choice, that you're just being difficult because you won't have a meal at a certain time or you won't go to a specific restaurant. The tears that we piece together and that happen every time we sit down to have a meal. Those ruminating thoughts that again are just relentless, that you have around meal times, that you have throughout the entire day. Or that panic when we realise we have had one bit extra of food that day than we'd actually originally planned to. The fear perhaps because someone else has cut that slice of bread. Or looking at our fingers and realise that we've picked them apart because the emotions feel too much. Those consuming thoughts that nag us day in, day out, that make us exhausted, that pain, the fear. The fact that even now on some days, I find it hard to fully engage with my baby because I'm ruminating over what I've had. Those are all symptoms of a malnourished brain, though. Imagine on top of that mental torment, though, that you sit down in a service asking for support, and you're told by that clinician that you're too complex, or that you can't be helped because you've had some sort of care historically. Currently, deaths in eating disorders happen all over the country. They shouldn't happen, but they do. This is due to decades of stigma, decades of underfunding, and decades of no training or proper research in this field. But the problem that faces us at the moment is that we're massively overstretched. Everyone knows that the NHS is so overstretched. And unless we get proper funding and treatments into eating disorders, it's just going to get worse. Deaths will happen in good services and services that aren't quite so good. And I honestly believe that it's these trusts that are feeling the pressure who often hide behind decisions that are made in court. They hide because they don't want to have that name put to them. But by marking all these individuals as untreatable, it sets a dangerous precedent across the sector and beyond. It also gives a really loud message to people who do live with an eating disorder, which, may I add, it is a treatable illness, but it leaves us feeling like we're just collateral damage in a wider issue. How many clinicians who advise in the court of protection have actually seen the outcome of people who fully recover? And you'll hear Dr. Agnes Ayton talking shortly about those individuals that have fully recovered. It can happen. You'll probably hear people say at times that That individual's been in treatment for decades, so let's just withdraw it. But what you have to remember is continuous treatment does not mean quality treatment. We wouldn't half fix a broken leg and expect someone to go out and run again. But yet we think keeping a person with anorexia, as an example, in a hospital on just a few hundred calories a day for treatment is enough. You'll also hear people say that it's inhumane that someone is being NG fed or restrained. But if that refuels that individual and it helps their brain, that can give that person a life. Hospitals are traumatic places. I know that I've been in one. You never forget the kind of stuff you see in a psychiatric hospital. And I'm sure some of you will probably agree with that. But is that a reason to dismiss a person who hasn't been given a chance to fully weight restore and get well? When you're in court looking at these cases, maybe look at the history of that individual as well. Look at whether they've ever got to that healthy BMI before you make that decision to mark them as untreatable. Last year, there was a case that went through the Court of Protection. I'm not going to say who the case was about. I'm sure some of you will be aware of it. But the girl had had anorexia for over a decade. She was marked as too complex. She was marked as untreatable in court. Her treatment was withdrawn because of that. She did also say at some point in that process that she didn't want to be alive anymore, that she wanted that suffering to end, that she wanted to die, that she couldn't keep living like this. Within a fortnight, she changed her mind. She started messaging me, I'm scared. I want to live. They say they can't treat me. They've marked me as untreatable. They've said I'm complex. I don't want to die. She begged me to help her. She begged her family, who then contacted me, asking what I could do. I told them to ring the judge again. They did that. They had another conversation. Because of data protection, and you guys will know that better than I do, there was a huge blockage on actually what we could do in that moment. She's now got a BMI of 7. She's had lots of heated conversations, and we all have over the last couple of weeks with various other eating disorder services across the whole country. The eating disorder service in her area will no longer treat her because of what happened in the Court of Protection. So we've had to find her a private placement in London for her to get that support. Her parents are having to remortgage their house to pay for her to go through that treatment. So when you're told we're doing that family a favour by removing the treatment, know that this thought to die could literally change days later. That individual, both the carer and the person with eating disorder, might not see a way out in that moment, and we have to help them find that. I know that Tor mentioned this whole postcode lottery at the moment. But in those moments when you're looking at what treatment can be there for that person, maybe look at what other avenues can be explored. Yes, we cannot magic up beds and placements elsewhere in the country, but you can request second opinions. You can get other people in to look at those cases. And again, reminder to look at their BMI historically as well. I'll end with this. You have the power to decide whether someone lives or dies in these moments. Yes, you'll listen to what goes on for that individual. I know you'll do your research. But remember that those that you might say can be marked as untreatable, those that get their treatment withdrawn, those that, in effect, you might be condemning to death. Many of them, days, weeks, months later, they might actually have decided they want to recover and they want to live. And at what point is it okay that we say we're going to withdraw that treatment? Thank you.
Brilliant. Okay, so thank you for the opportunity and allowing me to present today. The slide I've just put up here is just one slide, and it's little background information, which I'll leave you to read whilst I speak. Just before I start, I do have a small disclaimer. I do not have medical expertise, nor am I an eating disorder clinician. I'm just a mum, and nor did my daughter not choose this life path. However, what I do have is many years of lived and living experience. Outside of supporting my daughter, I represent the carer voice on several NHS working groups, working towards better outcomes for all those affected by eating disorders. So, I'll commence today with something my daughter wrote only a couple of weeks ago. I do not want to recover. I dream of it, but feel so defeated by this illness that I think I never will, and alas, I stay stuck in it. I think we're often blamed for being treatment resistant, or whatever phrase they want to use at that moment in time. I'm scared to lose my anorexia, even though I would do anything to be free from it. It's so confusing, and some people just do not understand. So, in the world of eating disorders, it's not uncommon to hear words such as complex, complicated, not engaged, untreatable. These words and statements used by some healthcare professionals to describe a patient who's not been able to move on and start recovery from anorexia after several years of being offered support in this illness. I have to be fair here, though, and state that at this moment in time, we are not hearing all these words from her current inpatient team. These words and terms used are very damaging and, for want of a better word, cruel. This is a mental health condition. Anorexia has the highest mortality rate of all mental health conditions. For those of you here today who maybe don't know too much about eating disorders, it could be hard to comprehend this high mortality rate. It should just not be this way. Evidence research states that when a patient is so ill with anorexia and the body is so malnourished, is cognitively incapable of thinking logically and making any decisions or any major decisions. These illnesses are very complex. I ask how one can possibly judge whether someone is of sound mind within this illness. Ask those entrenched with an eating disorder, and over time, many will have articulated they may not want to carry on living. However, this is simply not black and white. In reality, they are articulating that they don't want to live in the hell with the anguish that they are living with each and every day. They dream of a future, but when their physical health becomes so compromised, they are simply terrified. They are in fact screaming out for help. As a mother, we watch our daughter decline each day. It's incredibly hard to listen to her thoughts and comments, to know how to react when she makes the saddest of sad statements, when she tells us she no longer believes anyone can help her. She has no energy or fight left inside her. She's lost all hope. She's exhausted. She's too complex for help. And yes, we've heard that. In fact, we've heard it today as well. I just want peace now, Mum. I want to die. Statements no mother, no father, no brother, no sister should ever have to hear. Statements that come across very convincing. Statements that at that moment in time are very real to my daughter, and at that moment in time, exactly what she wants. Statements that if heard by someone who's unaware of how strong and how influential an anorexic thought and behaviours can be at any given time. But now here's the thing. There are days, sometimes weeks, sometimes months, when her mood is lifted and she's not in such a dark place. She's positive. We hear her laughing on the ward. She talks about her engagement with the support team around her. She looks forward to our visits. She plans outings. She wants to meet up with friends, has sleepovers. She's engaged in life. Even the simple things like getting her nails done are on her to-do list. All little steps of positivity. But far more noticeable are the plans she talks about and writes about for her future. She wants her own flat. She desperately wants to travel. And even more importantly, she wants to be able to eat baked beans on toast again. So why, I ask myself, why is there such a contrast in statements at any given time? The answer, as previously stated, is much to do with the malnourished brain. But secondary to this, and more immediate answer, is simply nutrition, food, and fuel. As my daughter has declined over the years, so too has her food intake. She survives on a very low-carb diet, and her BMI is hovering still around 11. We know, and certainly her current inpatient team know, that when she's able to start to increase her daily intake, then her whole persona will change. To evidence this a little bit further, I make reference to the Minnesota starvation diet experiment in 1944. Where a study took place to gain an insight into the physical and psychological effects of starvation on men. Findings concluded that starvation dramatically alters the personality, predictability, affects the mind as body. Starvation dramatically alters the personality and predictably affects the mind as well as body. The diet alone can have a large effect on basic bodily functions. And food deprivation has a dramatic impact on the cognitive and social functioning of those who are very malnourished. In the world of anorexia, it's not uncommon to hear terms such as assisted dying, withdrawal of treatment. This is just not right. With so much evidence and continued research out there showing that a person entrenched with anorexia simply does not have the cognitive ability to choose life or death. So I asked one question: why are eating disorder cases being brought before the Court of Protection? Why are they increasing? The illness hasn't changed, so what has? Just one answer could be is that eating disorders are grossly underfunded, and the limited resources they have to treat patients consistently and for long enough to ensure recovery are just not there. But is that a reason to withdraw treatment? And finally today, when there are many, many post-anorexic patients who can and do testify that when they're so very poorly and anorexia was so deep-seated in their life, that at any time they would beg to be taken out of treatment. These are patients who were told they were too complex for treatment and therefore untreatable. These are patients who had endured anorexia for many, many years. Patients who'd been told they had to stop engaging and patients who had been told they'd stopped engaging and were treatment resistant. And yet, here they are today, ready to speak up, able to speak up, and are clear examples that recovery is possible at any time for any person. They all cite the fact that they are thankful that in their lowest of low days, they were not listened to by their support teams. They kept on going and going until that moment in time when recovery finally commenced. And that is why no one with this illness should ever be allowed to be given up on. Never. Thank you.
Thanks, Nicky. Agnes, your slides should appear. Oh, you're doing your slides yourself.
Yeah, yes, thank
May appear.
sorry, I thought it was a good idea for me to share, so let me do it. Okay. Is this working?
Yes.
Yeah, okay. Well, thank you very much for putting on this event, because I think we probably will all agree that the most important thing is to have start having a conversation and trying to make sense of the recent trends and also what might be helpful going forward. So in terms of my introductions, apart from kind of having worked in medicine for the last 40 years and specializing in severe eating disorders for 25 years, I probably also should mention that I started my career working in neurology for 7 years. So I am very familiar with chronic and progressive neurological disorders. And I suppose, in my humble opinion, anorexia isn't one of those. So the key points for today, it's really important to understand that anorexia nervosa is a mental disorder and not a choice. And this distinction is vital in legal consideration, particularly when balancing between the Mental Health Act and the Mental Capacity Act in treatment decisions. And I would like to make the case that compulsory treatment can be life-saving. It doesn't need to be coercive. And there is no actually research evidence to suggest that compulsory treatment is harmful as long as therapeutic relationship is maintained. The second important point is that things change. So even with the terminal anorexia concept, which I will touch on a little bit later, we do not have a crystal ball or biomarkers to predict who will respond to treatment and when. So we really need to be very humble about this. And both qualitative research, long-term follow-up studies, clinical experience suggest that patients change their priorities with treatment. And I would also like to add that the field is progressing, even though progress could be a lot faster. The underfunding of services has been highlighted by both Nicky and Hope. And they are in good company because the Parliamentary Health Service Ombudsman raised the alarm in 2017 and then repeated his call highlighting the underfunding of services, insufficient medical training and variations in practices. I mentioned the progress in science, and a recent landmark genetic study of the biology of anorexia nervosa, particularly the study highlighted here by Watson and colleagues have shown that there is a significant association between multiple mental disorders and metabolic parameters. And this actually has significant clinical implications. So as you can see, the highest link is with obsessive compulsive disorder, but also with depression, schizophrenia, anxiety. And these conditions can be treated in addition to the eating disorder. The biology of anorexia nervosa is not fully understood, and we see multimorbidity. So the cases who have gone to the court of protection usually have complex physical and psychiatric comorbidities. And it's really important to emphasize that the Mental Health Act applies, and the mortality risk is related to no treatment. The regulation of eating behaviors is not fully understood, and this diagram is grossly simplified, but it highlights that it involves a complex interaction between the gut, the brain, and the environment, and these processes are highly sensitive to stress. So this complexity is not just a medical issue, but also a legal issue, as it influences how we view the autonomy and capacity of individuals with these disorders. Malnutrition was again mentioned by both Nicky and Hope. It plays a key role in perpetuating the pathology of eating disorders leading by multiple factors. One important contributory factor is that malnutrition itself increases stress hormones, so that leads to a vicious cycle of very high level of anxiety and stress in the patient. But the positive news is that normalization of BMI is a predictor of good outcomes. There's a robust finding in the literature. And furthermore, neuroimaging studies show the brain atrophy, which we see in severe anorexia nervosa, is reversible with malnutrition. In this context, it is a concern that the mean discharge BMI in the UK is about 17, which is still within the malnourished range. And we have done some work using integrated cognitive behavior therapy, and we're able to help the patients to achieve a BMI 20 on discharge, resulting in much better outcomes. As you can see, 1 year remission was 70% as opposed to 15%. So there are definitely positive options for treatment. And the qualitative work has shown by Dr. Jacinta Tan, the patient's views and priorities change with weight restoration. The emotional suffering in anorexia nervosa has been mentioned in several of the court of protection cases, and it really is impossible to overstate the emotional turmoil the patients go through. They often feel trapped in a cycle of self-hatred and fear, facing intense distress around eating and weight gain. And it is important that suffering is recognized both in treatment as well as in any legal approaches. It is also important to recognize that these feelings can pass even after prolonged periods of time. So these examples are from two separate patients who after treatment joined us in Hope's campaign to argue for improved funding in Parliament. And I suppose what I would like to emphasize, the compulsory treatment, whilst a difficult choice and it should be the last resort, shouldn't be regarded as the same as coercive or degraded treatment. These two patients in combination required 30 years of hospital treatment. And they responded positively to an integrated CBT model, which basically is a very individualized, integrated approach, combining nutritional, psychological, and medical treatment. And this is crucial in legal context and highlights the potential benefits and ethical considerations of compulsory treatment. So, given my clinical experience, I was very surprised to see the terminal anorexia paper, which was based on 3 cases and with a suggestion that an age threshold should be 30 years. Patients should be determined to want to die and had high quality treatment. And I must say, I was really kind of shocked to see that. And I was in good company because the first responses and very eloquent responses were coming by patients internationally, unprompted. And I would strongly recommend for you to read these responses by patients. And similarly, we had several experts in the field challenging the notion of treatment futility for anorexia, unless there is some additional life-limiting illness that is present. So I would argue that we can do better. Here I share a case of a patient who, despite needing several months of intensive care treatment, recovered. And this is a harrowing image to illustrate that even extreme cases are not terminal, and that the body and the mind have a wonderful capacity for recovery. And this should have an important consideration for legal judgment or treatment decisions. The UK is world leading in good practice guidelines. So we have excellent guidance for the treatment of eating disorders, including the safe management of medical emergencies. But as I mentioned before, adult eating disorder services are significantly underfunded. In a national survey, we found that only 15% of the funding required was available for frontline services. And this has significant implications on the ability of services to implement evidence-based and effective treatment. Also, research is on the funding, so the development of new treatments are lagging behind. In terms of a treatment hierarchy, it's also important to recognize that evidence-based treatments, which are supported by NICE, were done on the less severe patient population. So the randomized controlled trials are easier to do in an outpatient population. And we need to be interested or learning from different evidence-based, such as service innovation, which have significantly improved outcomes, and understanding these treatment and research hierarchies and the evidence supporting them is vital for making informed legal decisions. And my last slide is really to show that over the last century, we have seen significant changes in treatment approaches for eating disorders. And that applies to my own clinical practice. So when I started working in the field, probably I was also kind of following an operant conditioning, a restrictive approach. And adopting a more psychologically based approach for patients with severe and complex eating disorder has made a real difference in my clinical practice. And hopefully that will give hope for both for the patients and the court of protections when you're making decisions. So in conclusion, the intersection of the medical treatment and legal decision regarding eating disorders is complex, is constantly evolving. And I hope that my presentation has been helpful to highlight these issues.
In typically disorganized fashion, I've got most of my thoughts on my phone. Bearing in mind that I was likely to need to respond to what was said. I'm Ty Glover. I'm a consultant psychiatrist currently working in an inpatient unit in York. My background is a bit unusual in that I came from medical treatment and I did a lot of medicine and particularly anaesthesia and intensive care. So I have a very good sense of, sadly, what kills people. Massive trauma, sepsis, etc. 2002, I went into psychiatry, well, went into eating disorders, and oddly, just by chance, have treated inpatients of the most severe kind over many years. My involvement in medico-legal cases started one Friday afternoon with a phone call, and in one of those moments that you never forget, I actually remember where I was when the phone rang, and it was a lady from the official solicitor who said, "We've got a critical case, Dr. Glover. We need a report in a week. This patient is on a palliative care pathway in Wales, and we're in court on Friday," and it was on the Friday, so I had a week. So this was the case of Re-E, and the point I'm going to make, and Tor suggested, because this conversation can obviously, it's very multifaceted and very difficult to hold, and Tor said maybe stick with 5 points. So the first one is to talk about the first two cases which I'm aware of that came before the court, Re-E and Re-L. And then the most fatuous comment ever to put before a bunch of lawyers, which is the words matter. The third point is that I think the Mental Capacity Act has been a very good teacher for me. The fourth point is about these being very deeply personal tragedies. And the fifth point, which echoes a great deal of what Agnes and Hope have said, is that everything changes. So I'll start with Re-E, and so that phone call on Friday, and I went down to see this young lady who was on a diamorphine syringe pump because of her anorexia. And I thought she would have been treated as I would have expected, which is intensely against her will repeatedly. And I expected that the decision had been taken to withdraw treatment. I wasn't sure about the diamorphine syringe pump, given that she wasn't in pain. But anyway, you know, I thought that when I reviewed the notes, in fact, she had not been adequately treated. And I don't think any consultant in eating disorder psychiatry would have thought she was adequately treated. And I had, frankly, no hesitation in saying that this patient hadn't received sufficient inpatient, intensive, forcible, assertive, potentially against her will treatment. And that was the case of RE, which was in fact my first ever medico-legal experience. The first time I ever wrote a report was on RE, and the first time I ever gave evidence was in the High Court, which was an amusing moment when the official solicitor's representative explained to me that I was in the Strand in the Royal Court of Justice. And you can imagine my response. And that was my first experience of this situation. And this, I didn't think was a particularly difficult case. I didn't think RE was difficult. She hadn't been adequately treated. She had not had sufficiently intensive inpatient treatment to suggest that withdrawal of forceful treatment was appropriate. And actually, prior to us going into court that day, we got the message that she'd chosen life, which I suspect meant that she wished to engage in treatment somehow. That case led to clearly a consideration amongst a number of clinical teams about patients they were treating. And the next case that came before us, only a few months later, was Riel. And that was about as polar opposite as you could possibly have seen. This was a young woman who happened to have been in the hospital where I worked, but under a different consultant on a different ward, and had been treated many, many times, and had spent 13 out of 17 years of her adult life in inpatient treatment, most often being restrained to be fed, and most often resisting that treatment. She had a habit, and she ended up in a recognised centre of excellence in the north of the country. And when she was nasogastrically fed, one of the things she would do was she would bite off the nasogastric tube, obviously behind the teeth, leaving the nasogastric tube apparently showing, swallow the tube. And then when the nasogastric feed was delivered, she would catch it in her mouth and spit it out. This led to her suffering aspiration pneumonia on numerous occasions. And she'd been treated in intensive care on numerous occasions. She was in a very, very highly respected unit under a highly respected consultant. And they'd not been able to make any progress with her. Her BMI when I saw was 7.7. She was receiving 25 mils per hour of nasogastric feed, which was insufficient to keep her alive. And I said to her, what about we increase it to 26 mils an hour? She said, I'll think about it. And I said, but you might die while you're thinking about it. And she took a moment and she said, I'll think about it. It was not a difficult decision. In that case, I didn't think that forcible treatment had not worked. It was intolerable to her, and she did not want to undergo it any longer. She had had years of psychological therapy, which she had partly engaged with and partly not. So I think those early cases in 2012, one which I think was clearly inadequately treated, and one which I have to say, I think most consultants would agree had been very adequately treated, set reasonable parameters. So that was really in reality. My second point is that the words matter. Now, as I say, it's a very fatuous comment to say in a learned legal situation to point out to lawyers that the words matter, but actually, as many lawyers will know who instruct medics, that medics don't quite get it. Our attitude to language isn't the same as yours. You are very precise in your language, and we are not sometimes. She's a bit depressed. Well, does that affect her capacity? Well, no. Well, you said she got depression. Yeah, but it didn't affect her capacity. Well, has she got depression or has she not got depression? Well, she's a bit depressed. And that sort of language is not uncommon and actually not unprofessional. We in the medical world know what that means, but it's very confusing in the legal world. Are you making a diagnosis of depressive disorder? Is it mild, moderate, or severe? And what is its impact on the ability to understand, retain, weigh, etc.? That came home to me very quickly. But the other thing about the words mattering is, and it really chimes with what Hope and Dr. Ayton have said, that these judgments, from my perspective, have always been about not enforcing treatment because it hasn't worked. So in terms of the Mental Health Act, and I have to apologise, I may get this wrong, and in a room of legal people where I'm supposed to be an expert, it's perhaps embarrassing. I think the area of the Mental Health Act that we're talking about is appropriate treatment. Section 3 demands that appropriate treatment is available. And I guess what's been said in these cases is that appropriate treatment is no longer available. And so the Mental Health Act falls away and the Mental Capacity Act comes into play. That may not be an accurate interpretation of the situation, but I think it's a reasonable one. Now, appropriate treatment involves, in anorexia, obviously nutrition and psychological therapy. These patients are adamantly opposed to further involvement. They do not want psychological therapy. They do not want nutrition for whatever reason, and there's no doubt that it's an illness and it is a distortion of their thinking, but they do not want to engage in psychological therapy. So many of the avenues are closed to treatment. And as I say, most of these cases have been in the hands of experts and have been in the hands often of many experts. That doesn't mean that the treatment has been perfect, but it has been administered to the best of the ability of the people that were involved. So the judgments that I'm aware of have always been that treatment should not be given with which the patient does not agree. That has been the best interest decision. And as an independent expert, my role primarily has been to look at the cases, look at the care that's been given, obviously identify any deficiencies, but as a general jobbing psychiatrist myself, and I'm not a researcher, I'm not an academic, but I've worked in this for 20 odd years. I attend national and international conferences, have a suite of colleagues with whom I consult regularly. What treatment is available? What treatment do they want? What treatment will they agree with? And we have to remember that many of these patients have been profoundly traumatized. These are uniquely unwell patients. They've often been subjected to intrafamilial sexual abuse. And so one actually can't imagine, I won't say one can imagine, because I can't imagine what the process of being restrained and having a nasogastric tube forced down your nose and repeatedly fed, what that must feel like. The words have always been, as far as I'm aware, and I'm sure Tor, maybe just Henke will correct me, that they should not be given treatment with which they do not agree. That doesn't mean they don't get treatment. That's never meant they don't get treatment. If it has, then it's a failing, I think, on the medical side. And it's clear from Hope's comments and Dr. Ayton's comments that there may be patients that are being cast into some kind of rubbish bin. You've been through the course protection, there's nothing else we can do for you. Well, That's not true. That's not what was said, and not in any of the cases I've been involved in. What has been said is we should no longer force you to have treatment, not because we don't think it will work, but because it's been tried. It's traumatizing you repeatedly. There's a very good case that it might actually be making things worse. And in those cases, the best interest decision, of which I think the independent experts, that's only a very small part, has been that we don't think that is any longer in your best interest. And I say that the independent experts has only a small part to play because these are deeply personal issues. I come along 5, 10, 15, 20, 30 years into the process. And really, my role is primarily, a great deal of the letter instruction will consider the matter of capacity. Litigation capacity, of which there's a whole other talk, but you know, and capacity to make decisions about care and treatment. And I don't think there's any argument anymore that someone suffering from severe anorexia nervosa lacks capacity to make decisions about nutrition. The mental illness is so overwhelmingly in favour of avoiding calories that that balance cannot be seriously thought to be retained. That person without anorexia would not think that way. So it's often a relatively easy determination from an independent expert's point of view to say that they lack capacity, but their best interests are not, I don't think, something that an independent expert can confidently stamp all over. I've only just arrived. These people have lived with this illness for many, many years. The individual and the family, and often the clinicians working with them. And they reach that conclusion after a great deal of grief, and often because, as you see from home, and many of these patients, they are intelligent, articulate, wise, thoughtful individuals who will have researched all of the treatment options very often. So, from an independent expert's point of view, it's a very light touch. My view is that the best interest determination is of a light touch. Are the best interest determinations that are being discussed by the individual, their family, and the clinicians involved, are they reasonable? The third point I wanted to make is about the Mental Capacity Act in general, which may not be as pertinent to this evening's talk as it might have been, but I think it's still worth thinking about, because over the last 12 years, whilst I've been doing this work, it has changed completely my attitude to mental illness. And the framework that it gives you is to very carefully understand what is the impact of the mental illness on an individual's decision-making capacity. And in terms of, you know, should I have an apple or a Mars bar for a patient with anorexia, that isn't often difficult. But it helps with these difficult questions, and these come up every single day on an inpatient ward. Can I go home with another patient? Right, well, hang on. That doesn't sound okay somehow. The decision there you're being asked to make is, does that patient have capacity to determine with whom to associate, or to determine with whom to travel? Why would anorexia affect that ability? It won't. Are they using it to avoid calories? Well, they might be. That's a different thought. Can I go on leave? Can I go for a walk? All of these difficult questions which do come up on a day-to-day basis, they are so much more helpfully viewed through the prism of the Mental Capacity Act, in which one respects, as far as absolutely possible, an individual's right to decide, unless you can find a clear link between their condition and their ability to weigh matters in the balance and make a decision. So, are they going out for a walk because they want to burn calories? Yes, probably. So you may stop them doing that, but you've got a very clear reason why you're doing that. And I think over the last 10 years, it has changed my view. And I think it has, I mean, the one area which completely changed me is in medication. I now pretty much never enforce medication, because there is no medication which, I'll come to it later, but there is no real medication which will definitely make a difference sufficiently to override their will. So when we use olanzapine, it may cause weight gain. That may be sufficient to cause a patient with anorexia to refuse that medication in an incapacitous way. But that prism is so helpful, because what I think it does is it allows you to respect the individual in a holistic way, rather than making a judgment that because they've got a mental illness, they can't make any decisions. And that is why I think the MCA has been a very good teacher for me. The fourth point I want to make is that these are rare and very, very personal tragedies. There are 400-ish beds in the UK for adult eating disorders. Average length of stay is about 3 months. You're talking about 1,600-ish admissions. So over the last 12 years, 20,000 admissions. Barely a handful of these have come before the court. And inpatients are a minority of eating disorder patients. So you're talking about a small percentage of a small percentage of patients. The individual circumstances, which can only obviously be made known to those intimately involved with a clinical case, are often of such extreme trauma and distress that it would be insulting for any of us to say we can imagine what someone's been through. Undisclosed intrafamilial abuse, alcohol misuse, multiple complex illnesses, and an absolute refusal on the patient's part to want to engage anyone. They just don't want to. They know what the treatment is. They know that there is a 10, 20, 30, 40, 50% in some circumstances chance of recovery, but they don't want it. Now, they don't want it because they don't want to gain weight. So they lack capacity to make that decision. But is it in their best interests? Is it really in their best interests to subject them to another year or 2 or 3 of restraint feeding when they and their family and the clinicians looking after them say it is not? They're the cases that have been presented to the Court of Protection. And in none of those cases, well, there is actually one concern. I think one of the cases would not meet this, but generally speaking, In none of those cases has the judge said this should be terminal care. No one has said this should be terminal care. Put this patient to sleep, give them a diamorphine syringe driver. Never. They have said, we do not think it is in the patient's best interests for them to be treated against their wishes. That has been the critical judgment that has been made. If patients go through the course, and all of these decisions, as we all know, are time and decision specific, if those patients change their mind, then that dynamic changes. They cannot be abandoned. They shouldn't be left on their own just because they've been through the court. They should be supported as far as possible to remain at a low weight, with all of the physical complications being attenuated as far as possible. And should they reach a point where they do want to engage in psychological therapy, or they do, on occasion, agree to nasogastric feeding, there's no reason from any of these judgments why that should not be allowed. If it isn't being considered, that is a flaw, I think, in the medical process, not in the legal process. My final point really is that everything changes, and that covers what I've just said, which is patients change. I have never so far had a patient of my own go through the course of protection. I currently have a patient in her 40s with a BMI of 12. We are trying to arrange for her to go home with nasogastric feeding at home. She wanted to die. 12 months ago, she didn't see a way out. She couldn't see a way out. She doesn't want to engage in weight restoration. She's a very intelligent, articulate woman, but she is prepared to consider a treatment plan whereby her BMI is maintained at 5 or 13 with nasogastric feeding. There's nothing wrong with a gastrointestinal tract or a mouth. She doesn't need nasogastric feeding other than because of her anorexia. I have previously treated a patient for over 3 years who was restraint fed and who is still well, although has other mental problems. So no one comes at these issues lightly, and the dynamic is constantly changing. Dr. Ayton's research is very significant, and we are only looking at it. It does involve intensive psychological therapy, with which a patient must obviously engage. If they're saying they don't want to, what are we going to do? One thing that has changed recently, and it was November last year, Professor Nutt from Imperial spoke about the potential impact of psilocybin, magic mushrooms, the active ingredients in magic mushrooms. And there does seem to be a genuinely potentially transformative effect from this single dose of this medication, in not just in anorexia, actually particularly in obsessive compulsive disorder, which is of course a close cousin of anorexia, but also in substance misuse, depression, and other conditions. And I have thought, after having heard his talk, would that have changed my thinking, or would it, more important, would it have changed the thinking of the clinicians involved in that case? Because it's not my job as the independent expert to say what should happen. It's, are we where we need to be? Have they done what they should do? Is the capacity determination correct? What else could be done? With the potential for the use of psychedelic medication, should we be enforcing that in cases that appear futile? I don't know. But it is certainly an arena, and it's obviously something that must continue to be considered, because best interest decisions will change daily. The court only makes a determination on capacity and best interest at the time and with the evidence that is presented to it. If those facts change, the capacity determination may change, and the best interest determination may very well change. So it cannot be that a court determination is final. That's why the words matter. But having said that, these cases are very, very difficult, deeply emotional, and often very difficult to deal with for the lawyers and the clinicians involved. Never mind the patient and their families, who go through unbearable feelings which we just can't understand, frankly. The approach of the court in terms of protecting a patient's right to decide if they retain capacity, and then subsequently to protect that individual if they lack the capacity to decide, is crucial. And I have to say, the striking thing that occurred to me, in fact, I think the first or second time I came out of court, I said, everyone should go into that court. It will restore your faith in justice. Because the sensitivity and empathy of the legal teams involved has, I'm afraid, on occasion, put my psychiatric colleagues to shame. And the sensitivity, thoughtfulness, and forensic analysis of the facts that has taken place has been salutary, really. My role is, or an independent expert's role, is slight. It's marginal. I don't tell the judge what to do. No one tells the judge what to do. I just advise, does this look like they lack capacity? That's not often a difficult determination. It's challenged and cross-examined, people like Tor and Nicola, to the nth degree. And then it comes to best interests, and really, is an independent expert the right person to make that judgment? No. Is the independent expert entitled to say that looks like a reasonable best interest determination? Yes. But that then falls before the court, and that analysis, which overwhelmingly involves consideration of that specific individual, their specific emotional, psychological, and spiritual needs, is what the court addresses. And at that point, the judge makes the determination. And in that respect, I think the Court of Protection is uniquely well placed to make these considerations, and in my opinion, should continue to do so. Thank you.
Well, food for thought. Questions from the floor, I think. There we are. Come and join us, and I think Nicola and Mungo are going to come and join. No? You sure? All right.
I've got a long list of questions from the internet, so.
Fraction of the room. Shall we start on the internet?
I'm a family lawyer, and as a consequence, a number of my clients have overcome anorexia and gone on to have children. And I'm very interested that from a social work perspective, anorexia was seen as a self-harming symptom rather than an illness in itself. And I'm so interested in the points raised tonight about the idea that in fact it's a heavily traumatized person who's gone through years of their own self-discovery and their own clinical pathway taking control. And so for that control to be wrested from them by the court and by clinicians, it's sort of oppositional. So do you see it as a clinician, as a form of a patient taking control by not eating, as almost a way of...
Sure, it's not right. I mean, it's an illness. It's not self-harming.
It's also not about control.
No.
And I think that's one of the massive misunderstandings and stigma that is attached to anorexia, that everyone thinks it's about control. Everyone looks at the pandemic and thought there was a rise in anorexia because everyone was out of control, and that's not the case. It's a biological mental illness. And when you have anorexia, you are not in control of anything at all.
Yeah, and I would add to that, I'm a mum, by the way, just to say, you're wondering who I am. I would just say that I think control can be a symptom, so it can feel that way. So I think we've misunderstood when talking to patients with anorexia. They talk about a sense of control, but I think that's rather a symptom of the illness rather than a cause. And I'd also say that it's a bit of a misunderstanding that everybody with anorexia is traumatized. They're not. Many people just fall into it by becoming a little bit malnourished. They go on a diet and then something in their brain kicks in, because as we saw, there's a high genetic basis to the illness. So it will emerge from slight malnutrition or losing a bit of weight. Then they'll just become obsessive around it. So I think talking about sexual abuse in the family and things like that, I don't think there may be, but I don't think there's any evidence that that's higher in the anorexia population of people with anorexia than in the general population.
And sorry, just to add, Bella's not my mum. I feel like it sounded like
mum.
Yeah, she's in but she's got a brilliant blog which will make sure everyone gets circulated afterwards, which looks at the science behind anorexia as well.
And that leads on to one of the questions online actually, which was for Agnes, probably primarily, which is about autism and neurodiversity and how that links into eating disorders, and what the sort of effect is of autism on your presentation as someone with anorexia. I know that's also a massive topic, Agnes, but in 2 minutes.
Well, I'm not very good at 2 minutes. I think if we look at the cases who have been taken to the court of protection, I was concerned that there might be an overrepresentation of people with autism, and this is kind of a recent recognition in the field. That actually there is an overlap between autism and eating disorders, and various forms of eating disorders, so not just anorexia nervosa, but ARFID is another one. And I suppose what I was kind of trying to say, that science is rapidly evolving. These recognition, well, actually, there may be a link with autism. There could be a problem with gut-brain interaction in autism that contributes to difficulties with eating. And obviously, if we understand that better, then we will have different treatments. In terms of current treatment, I was talking about the integrated cognitive behavioral therapy. It's flexible enough to any comorbidity, so whether it's autism or post-traumatic stress disorder or any other individual presentation. And in our experience, but the numbers are quite low, in our clinical experiences, that the patients actually quite like the cognitive behavioral therapy because it's structured, it uses kind of writing, behavioral experiments, etc. So that it can be actually very helpful for people with autism. So I suppose what I would say, yes, there is an overrepresentation. Yes, there is a concern that people are more kind of chronically ill, but I wouldn't be hopeless because the field is improving.
Yes, question for Dr. Ayton, really. It's about the use of your contrast between compulsory and coercive. And you've made that one of the kind of key points of your talk. What Ty was talking about, how words matter in this field and other fields. And as a lawyer, it wasn't clear to me how you draw that distinction in the treatment of severe eating disorders. I wonder if you could just give something more tangible about what falls into which category and where the dividing line is. Particularly because when we're in the court, we're dealing with sedation and restraint and those types of concepts. And it wasn't clear to me how they fit into that contrast that you drew.
Yes, I mean, I think that's a key issue for the Court of Protection. And again, reading the case histories, I was kind of quite concerned that there was almost like a dichotomy kind of put in front of the court to say, well, if somebody has compulsory treatment, then that will be horrific in some ways. And it is the clinician's role to find the least restrictive intervention. And I have written about this kind of quite a long time ago, but the other person who has done kind of significant research on this area is Jacinta Tan. I sent some references, and basically the research is consistent that even if the patient is detained, all efforts should be made to find collaboration with the patient and helping the patient understand the rationale for the treatment. And that does make a difference. So the two patients who came to us in Parliament were extremely ill, and you can't actually see that when somebody is recovered because you know, you can't kind of look back in time. And you know, shall I say I was really pleased or delighted to see that they could recover even after, you know, altogether 20 and 10 years of revolving door hospital admissions. So and there was a question actually from James in the question and answer thing about, you know, do we have research predicting that past treatment failures predict future treatment failures? And I don't think that we do. So having the here and now is actually really quite important.
Can I just add to that some people that contact me who may or may not have been through the Court of Protection, but have had their treatment withdrawn, which is something, like I said when I spoke, is something that we are seeing a lot more of at the moment. One person in particular, she was very much didn't want to be NG fed, she didn't want to be restrained, any of that. She found the whole thing really traumatic. She ended up on ICU and actually got treated there originally for, I don't know, a couple of months, however long it was. She then went back into another service and got given another treatment, and she fully recovered, and she's now in a really good space. And I think it is when you're in that mindset and you're really, really unwell, any sort of treatment that is imposed on you, you're going to think it's coercive, you're going to hate it, you're not going to want it. But I believe personally that that's why it's up to the treating clinician to actually think, do you know what could this look like for that person, so we can make it work? Because any sort of treatment withdrawal is, in my belief, is giving up on that patient. And I know that, as Ty said, people aren't abandoned when they go through the Court of Protection, but a lot of the people that I talk to are abandoned when they go through Court of Protection and they're told then they cannot get that treatment. So I do think that, yeah, I do think that actually that treatment does work in the long term, and people will also change their mind. And Molly, apologies, one of the people that Agnes shared in her descriptions, she now will look back on that and she's actually said to Agnes in the past, I'm grateful that I went through that and you made that happen, because now I'm living my life, I'm at university, I'm going out and doing stuff.
Can I also add that I think people often misunderstand the reaction of somebody who has anorexia, particularly when it's very severe and it's really coming from somewhere deep in their brain, that it's not that they don't want to recover, they're just, often the prospect of death is less terrifying than the prospect of eating, and it's actually a fear response in their brain. So I think people have mentioned fear a few times, and it's really essential to understand that, you know, those people are just terrified of eating and gaining weight. So it's, in my opinion, it's the clinician's responsibility to find a way to guide them through the fear, because the malnutrition, they're not going to have a light bulb moment where they can engage with therapy, where the therapist is they're going to go, oh yeah, this is silly, I don't know why I'm doing this. You know, they have to gain the weight and they have to get back to a healthy weight and get out of that malnourished state before they're, you know, before they'll be able to engage in any kind of therapy that's going to have any effect whatsoever. So, I mean, don't get me started on BMI of 17. That's lower than a BMI of probably where most people are, the kind of anorexic thinking. So it's not helpful to just get somebody to that very low BMI. You need to get them to a proper healthy weight. I mean, but Nicky mentioned the Nicky mentioned the Minnesota starvation experiment, which was done post-war, and most of those men added 9% to their original weight where they started, and many of them were still obsessed with food 6 months after they were weight restored. So if that's the case for a normal starvation, it's very likely to be the case for the brain of somebody with anorexia as well.
And there's another question that follows on from this on the online questions, which has come from someone who is involved in investigating the use of longer term sedation in intensive care in order to provide feeding. So to avoid the conscious experience of being forcibly fed, using admission to ITU for a longer period. And that is something the Court of Protection is familiar with in cases where people who can't make their own decisions need treatment for a physical health problem and aren't capable of tolerating the interventions that would be needed, and so might need to be sedated for a much longer period than someone who didn't have those difficulties. And the question, I just want to know what the panel's reviews were, and I don't know, Ty and Agnes, whether the use of longer term sedation in intensive care is something that you've experienced of.
I've not experienced it. The plus is that the malnourished brain is refed and is woken up in a nourished state. The downside is that it hasn't gone through the psychological process of coping with weight gain and coping with eating, and also, of course, you're subjecting somebody to 2 or 3 months of a very risky procedure, you know, intubating and ventilating somebody and sedating them when the lung, everything is fine except they're eating. But you know, I'm open-minded. I mean, if there were any studies that were able to show this, it would be very helpful. And you know, a lot of patients in these situations have said to me, "Can you just put me to sleep and wake me up when the BMI is 18, please? I don't want to go through it."
It's really, can I just add?
Yes.
Yeah, it's really hard, and I do think that it's important that people relearn to eat normally. It's really, really important in the retraining the brain, so the brain learns that that's not something to be scared of. But can I just also add that one of my big concerns is that that we don't have the resources to treat people in that fashion, and I'm worried that we may be going to sort of NG feeding because people aren't able to sit with their patients for you know, 2 hours while they eat a meal, because that's probably how long it's going to take. Do we have the resources in the NHS to treat people in that way, which in my opinion would be the best treatment? And it's actually the treatment that was used by Dr. William Gull, who was Queen Victoria's physician 150 years ago. He fed his patients every 2 hours fats and protein and highly calorific food, and they did it every 2 hours, and they did recover. We don't know about their psychological state because we've got no follow-up studies as far as I know, but he wouldn't take no for an answer. You know, the instructions were sit with them while they eat and don't take no for an answer. And I just worry, I'm troubled that the NHS doesn't have the resources to do this, and so they're taking shortcuts, and these cases are ending up in the courts, you know, where maybe it doesn't have to be that way.
Yeah, there's another question online about resources, which is a practical question. What do we do if there are no specialist placements being offered, if there's no SEDUs saying that they'll take someone? And so your only option that you're presented with it from a legal point of view is forcible feeding that the person doesn't want, or care at home, which doesn't involve probably very much, if anything, by way of mental health support. Agnes, do you want to say something about that?
Yeah, I suppose I just wanted to come in about kind of considering alternatives to nasogastric feeding under restraint. So obviously, the restraint is something that you know, with appropriate kind of clinical management could be avoided or kept to the absolute minimum, and that would include kind of trying to engage with the patient even if they are very unwell, using psychological techniques, and also using kind of specialist nursing input to help the patient overcome that terror, what you were mentioning, Bella, and also kind of using psychotropic medication to help the patient calm down, because you know, the genetic studies kind of show that there is an overlap with OCD and schizophrenia. So psychotropic medications can be helpful for these patients if they're very distressed. I never had anyone in my 25 years who needed intensive care unit NG feeding because of the level of distress, and I would be very concerned if that happened. But in desperate cases, you know, sometimes you have other alternatives. So kind of you really need to disentangle what causes the extreme resistance. You know, is that autism? Is that depression? Is that a psychotic process? So what is the reason for that? And try to treat that the best you can. So for example, when we had patients with treatment-resistant depression, anorexia, we have been using kind of novel treatment like ketamine or psilocybin might be an option, and the patients are interested because they are suffering. So you don't actually have to enforce these things. The other thing that can be extremely difficult is somebody has intractable vomiting. And again, you know, we have ways around, so we can use parental nutrition, or we can use other kind of intervention that can kind of provide an alternative for the patient. But we also need kind of more research into that, because, for example, I think the most dangerous version is intractable vomiting, and we don't really understand what the mechanism is for that. So I don't know whether I'm answering your question, but I'm sort of thinking maybe the issue that Tori, you mentioned previously, kind of second opinions can be quite helpful in these cases. Just to have kind of a fresh look at what has been tried and generate some solutions together.
Can't see that.
Yes,
I'm from the ICB, the Integrated Care Board, which is the commissioning side of health, which gives the resources to the different types of services. Yes, resources are low, and in terms of commissioning, we are fighting all of the time to be able to commission specialist placements around. I'm up in North East London, so around our different areas. I've also worked in an acute trust and a mental health trust previously around safeguarding, and one of the issues that I see is in the transition between mental health services, so specialist mental health placements, into acute trusts and into acute placements. So what happens when a patient comes in very, very unwell from an eating disorder is they're put into an acute trust, and we work with medics around delivering services around trying to make them well. But what we lose there is the psychological input, and we're not great at that multidisciplinary working, although we try to be, to bring in that psychological aspect. So we're working on keeping this person well, alive, you know, refeeding and those bits that need to be done. But what we're losing in that time that they're in the acute trust is that psychological input. Plus, we're a little bit scared of that as well. And we're not very well trained in that also. So we don't really know what we're doing. So we're reaching back out to psychological services, but to psychiatric services, psychological services, but they can't then tell us how to do the medical parts of that. So sometimes those services don't work very well together when we're trying to make someone well enough to be able to get back into those psychological services. And we're also a little bit scared of taking that to court of protection because we don't do it very often. So sometimes that's a bit of a barrier as well. So there are some issues with that transition between the two services as well.
Yeah. There is no textbook on the management of anorexic patients in an inpatient setting. No.
Can I disagree with that just a little bit? So the Royal College of Psychiatrists kind of produced the medical emergency guidance, which is an update from the previous, what was called the Marzipan guidance. So there is a lot of detail in the medical emergency guidance around the how to do it. But the lack of resource is an issue. I mean, there were 20,000 admissions of adults last year to hospital with potentially life-threatening anorexia, and we have 450 beds. So the majority of the patients go to acute hospitals, and the resources are not necessarily there in terms of training, environment, a psychological input that would be helpful. Nicky?
Yeah, so I was just going to add from a parent's perspective, in the last few years, my daughter has not been into SEDUs and she's been too ill to be at home, so has been put into general hospitals, onto gastro wards, into a general acute mental health unit, none of which have been at all appropriate for someone with an eating disorder. Through absolutely no fault of the nursing staff. A nurse has less than an hour and a half's training in a training course on eating disorders. We've been many accident and emergency times we've had to go. Again, accident and emergency departments have no knowledge, no understanding of MEAD, which Agnes has referred to, medical emergencies. So there's a lot of resource issues. There's a lot of situations where, as I say, it's not through any fault of any hospital, any general hospital, any nursing staff, but it's the SEDUs where this patient has to get so ill. It's very unusual to have a person admitted to an eating disorder unit with a BMI of 15, 16. Their BMI has to go very, very low in order to get one of these coveted SEDU places. And I just actually, whilst we're on this subject, would like to point out that I think it's been mentioned a little bit here, is that not everybody with an eating disorder comes from a background of abuse, of sexual abuse, of alcoholism, or any other traumatic. Some people just get an eating disorder, and it's because it's in their system, it's happened, but it certainly doesn't come from everyone with an abuse background.
Can I just add one thing? So I know we're running tight on time, and this is from probably a much more campaigny aspect, is I know, and the NHS is amazing, and I know there are resourcing issues, but I still don't believe that as a reason to withdraw someone's treatment through the court of protection if they have an eating disorder, regardless. Yeah, I know we all have different opinions on that, but I feel very strongly about just emphasising that when their resources are tight, there are other options that should be explored.
So just to be clear, resources are never a reason given.
No.
No, but it quite
protection.
often sounds like we're hiding behind that at the moment.
And I don't think it is, because as Ty says in Re-E, he came in, looked at the evidence and said, well, you haven't done all the things you should have done. Go and do that.
And in a case,
And
18 months ago,
yeah, exactly. So
they had to shout
it's-
quite loudly.
yeah.
When not enough's been done. No, you're absolutely right. And I think the other thing that no one explores is whether there is a supportive, I think the Scandinavians do it, in an ultra low weight outpatient clinic, where you minimize as far as possible the physical health complications, whilst not necessarily challenging the core condition, to maintain somebody's quality of life, and also waiting potentially for the time for, I'm sorry to be fatuous, but simplistic, the penny to drop. They don't have to be, these patients should not be let go. They are very, very seriously ill. They're just not going through a coercive treatment pathway. That doesn't mean they don't get anything. They should actually get more. They should get, but everybody's so frightened of these patients at BMIs of 11 and 12. And that's where, to some extent, my intensive care background, because no one dies because the BMI is 11. You don't die of BMI of 11. You die because your heart stops, which might be more likely to happen at a BMI of 11. But there's no exploration currently, because everybody's so terrified that actually, can this patient stay as an outpatient? Can we see them every week, twice a week, 3 times a week? Do the bloods, weigh them, do their ECG over and over and over again. Support them, give them psychological therapy where they want it, and gradually, will they come on board? Or will at least you maintain the best quality of life you can for someone who does not want to go through forcible feeding? And you know, that we don't do at all.
We probably have to finish in a minute, but can I just, there's one other question I really hope to answer if she is happy to and has an answer to it, just because I'm certain that there are going to be people online, if not in this room, who would love to know the answer to it. And it's not a legal question at all. The question is if you are looking after or caring about someone who is in this situation of saying, I don't want treatment, I've had enough. What should the rest of us say? What is there that we could say to start a conversation with them?
Good question. Feel free to send them my way as a starter, or to Agnes. But I honestly think it's really hard. And like I said, I was in that position when I wanted to die. And even when you said about people staying on a low weight, the eating disorder part of my brain that is still there longs to be at that person, be like, oh, I could be that person on that outpatient ward at that really low weight. But I think part of it is about hearing stories of people who do fully recover. I know statistically it's really, really low at the moment, but people do make that full recovery. And for me, what hangs me on into that is knowing that at some point I will also get to that point. I've just got to keep working at it. And these individuals can get there. I think it's looking, and again, we can share case studies, we can share more research, but reminding people things like length of illness doesn't mean they're never going to recover, but it's because they haven't had the right treatment in place as well. And then a big thing that I've talked about, and I know Bella mentioned it as well, is that fear aspect. So trying to sit down with that individual and understand what is the fear that's stopping them progressing to that point where they're able to engage in the treatment. Having those conversations, kind of, yes, sitting with them for hours potentially. And a lot of, like, through the campaigning I've met a lot of people who I've literally just sat with in hospitals and listened to them reel off all of their fears and things like that, trying to get them to see a way out. And sometimes that's what you need, is alongside kind of providing that hope that people do get well.
We probably have to stop it.
Well, we are going to stop. But I think as a guest here, we should thank our speakers because it has been stimulating. So I understand there are refreshments, and can I just remind you of BEAT and SMS shout to 85258 if something has resonated or triggered with you. You're not alone, reach out. Thank you.
Thank you. Thank you, everybody.